Okay, looks like we're live without an intro, maybe. Producers, is that correct? Okay, hopefully we're live. I can't tell what's going on. That's how it is with live. Okay, hopefully we're broadcasting. If we are, somebody put in the comments so I know that everybody is here. Um, this week we are talking about contracts and what you need to know about contracts, how to read them, and what provisions you need to be paying particular attention to in the contracts. So I'm going to start this off with a quote. I'm going to start this off with a quote that I saw. This was from an Ohio case, but I got it because it's generally applicable throughout the country. This is the position. So a lot of times what I tell people is you need to read the contracts. I'm kind of concerned. Uh, Somebody put something in the comments if we're here. It kind of doesn't look like we're broadcasting. But I'm gonna keep going just in case we are. So, um, this case, this is what the courts will say about reading contracts. I always tell people read the contract before you sign it. So the court says it is somewhat unusual that a court should have to tell people to read a contract. But one who signs a contract without first making a reasonable effort to learn what's in the contract may not, in the absence of fraud, then object to the contract. So basically, what they say is one of the most celebrated tenets of the law is that a document should be read before you sign it. And the corollary to this rule is that a party to the contract is assumed to have read it. And if you didn't read it, you can't complain about it, basically, is what they're saying. Um, that part is, for the most part, true, but of course, you may still have some defenses to a contract. The important part to remember is the law is going to hold you responsible for what's in the contract. You should read the contract. So now I want to talk about a lot of people misunderstand what a contract or an agreement is, and so so I want to go over that. And I'm sorry. So one thing is I couldn't get, well, maybe my notes have printed. This is live, y'all. I told y'all on the first episode that sometimes things may happen. And but I wanted to get my notes in front of me so I don't have to keep looking to the side of my screen over here. And my printer just all of a sudden has been working all day and then didn't want to work right before the podcast. So okay, the elements of a contract. So what this means is in order for a contract to be valid and enforceable, it has to have certain key elements. It has to have certain key things. Like, so the elements are there has to be a valid offer, there has to be a valid acceptance, there has to be something called consideration. And then, as a side note, of course, the parties have to be legally capable of contracting. And the parties have to freely give their consent. There can't be any coercion. But of course, with offer and acceptance, someone has to make a valid offer, someone else has to accept. The part that most that contracts get hung up on is something called consideration. Now, consideration is value that's given to support the contract. If there's no value given to support the contract, then it's not going to be held to be a valid contract. So, you need to have the consideration. It has to be something that is of value and both parties exchange value, like a promise for a promise. I promise to pay you if you promise to give me the car. That's consideration. But another thing, it could be, it can be money, it could be your promise to not do something. Anything that's of value, real value, can be the basis, the foundation that supports a contract. That's what's called consideration. So if you notice anyone has bought a house or anyone has seen a deed or anyone has seen particular contracts, it'll say for and in consideration of good value given. That's because in order for a contract to be enforceable, Consideration has to be a part of it, and it has to be valuable consideration. And it has to come from both parties. So, what is it called when maybe even if two people agree or two people are involved in a transaction and one person gives value and one person just receives it and they don't give any value? That's called a gift. So a gift cannot be the basis of a breach of contract claim. That's why sometimes people sue about something and the court determines no, that was a gift. The most popular thing is a wedding ring. Sometimes a man will give a woman a ring for an engagement and then she'll break it off and she'll want the ring back. So he will sue. In some jurisdictions, they say that the ring is a gift. Some jurisdictions, they don't, they say it's not a gift. But in some jurisdictions, they say the ring is a gift. And so just because whichever party broke the agreement off to get married, that doesn't mean that they can get the ring back. So the important part of what I just said is what a lot of people don't know is a contract is uh, not just an agreement written on paper or something that's spoken orally, because you can have an oral contract. It has to have all of the correct elements in place in order for it to be enforceable in court so that if somebody breaches, the other person can recover for that breach. So don't forget, your words can bind you in a contract. Be careful what you say. There are states that recognize oral contracts still. Most states do. So you'll want to be mindful of that. So, express contracts and implied contracts. Sometimes you can have a contract just out of implication of the situation. It doesn't have to be written and it doesn't have to be clear what the parties say. We're going to enter a contract. Sometimes the law will imply a contract. You have to be careful about that. And then, a lot of times too, there's something called the parole evidence rule. And what that is if you've ever entered into a contract and you see it's going to say, um, okay, our entire agreement is within these four corners of this paper. Everything we've agreed to is on this paper and it's not anywhere else. People will put that in a contract to keep you from introducing other evidence of the contract. For example, you go do a contract to buy a car, right? And then, but the salesman sends you a text and says, I know the tires are flat. I'm going to give you four new tires. That's what he tells you in the text. But when you bought the car, you signed a contract that said, there are no other agreements. There's no other pieces of paper. There's nothing else I'm relying on. Everything we've agreed to is on this paper. So, but your salesman say, I got you. Don't worry about it. I'm going to get you the four new tires. Then what happens is you sign the agreement to buy the car and then you like, okay, like maybe a day or two later, you want to come, you say, okay, well, where's my new tires? And a dealership management is going to be like, we didn't agree to four tires. And you be like, my salesman said he would. Look at this text message. If you go to court, they're going to argue the parole evidence rule to say you can't bring in anything outside of this paper that you signed because you signed it and you agreed that the only agreement was here. That's why when you're doing a transaction like I described, it happens all the time. You buying a car, if the salesman says he gonna get you four tires, whatever anybody else says to you, or even if they write it on another piece of paper, you want to make sure it gets inside the contract that you're signing because they're gonna argue that it's not in the contract you signed and that you agreed that everything was in there. So you have to be careful with that. Um, so what I'm going over right now, because I know I said what this is about is I'm going to tell you provisions in contracts that you need to look for when you out here conducting everyday business so you know what they mean and you know what you're binding yourself to. I need you to understand though the basic framework of contracts and how they work. So what I've gone over so far is what they tell us on the first day of law school. Don't sign anything you haven't read. And I started by reading you a blurb from an Ohio case that really represents what the law is nationally. You're going to be held responsible by the court for knowing what's in that contract. You cannot go to court saying you didn't read the contract. It's not acceptable. So always read. If you got to sit there and read, so be it. What I do sometimes, like when I was renting apartments, I would call ahead to the leasing office and say, hey, can you send me the lease? Because I need to review it. And then sometimes they say, oh, no, we don't send our stuff out ahead of time. You have to come in. So then I tell them, I'm just letting you know I'm a lawyer and I'm going to sit there and read all 32 pages or whatever it is, right? And you'll have to wait while I do that. I always get, because they don't want to sit and wait while I read the whole contract. So you can call ahead a lot of times and get the contract. If somebody is hesitant to give you a copy of their contract ahead of time, that's a red flag. They should be willing to do that. So I talked about that, reading the contract, and then I told you that there's elements of the contract. Just because you sign a piece of paper doesn't mean it's valid legally. Once you get into court, certain things have to be proven. You have to prove there was a valid offer that was accepted in a valid way, that there was consideration that was proper consideration to support that contract, and that the parties had the capacity in order to enter into the contract and things like that. So you have to do that, okay? Now, I want to tell you about one more thing. It's called statute of frauds. There's something called the statute of frauds that applies to contracts. That comes from way back, the statute of frauds, I don't know, 1500s, 1600s. It's really old. But what that does is it requires that certain contracts have to always be in writing in order to be enforceable. They can never be oral. Now, so this is how the law works. You got to nitpick what I just said. You can enter an oral contract for these things I'm getting ready to tell you, and you can operate on that with you and the person. But if you ever want to sue on it, it's not going to be valid in court because you didn't put it in writing. There are certain contracts that always have to be in writing. Those contracts, for example, are the sale of land. You can orally promise to sell the land to somebody, but if you want to enforce that promise, like if the person doesn't do it, you want to take them to court, it has to be in writing. Any contract that's going to last longer than a year, with some minor exceptions that I won't go into here. But if a contract is going to last longer than a year, it needs to be in writing. So guess what? This is important for leases, right? So if you're going to do a 1 year lease or a 2 year lease, that needs to be in writing. But if you're going to do a 6 month lease, generally it doesn't have to be in writing. You can agree with the landlord in words that you're going to lease the place for 6 months or for 1 week or 2 weeks. Now, does that generally go on? No. Everybody these days has a contract. But just to let you know, that's an example of a contract that wouldn't last a year that you didn't have to have in writing. Okay. So what other contracts have to be in writing to be enforced? Goods, purchases of goods that's over $500 for the most part. Watch this. This is another tricky legal thing. Agreements in consideration of marriage. What are those called? Prenups. Agreements in consideration of marriage. Now, watch this. I didn't say agreements to marry. You don't have to put the agreement to marry somebody in writing, but the agreements in consideration of marriage, meaning I won't marry you unless you do X, unless you do Y. Like, I won't marry you unless you agree that you won't take my house if we get divorced, different things like that. A prenup, right? Those have to be in writing. If you promise to pay the debt of another person, that has to be in writing. What's that called? We all know in our common everyday language, a cosigner. If you are a surety or a guarantor for someone else, that has to be in writing by law. It can't be an oral promise. So once you have a contract in place, once again, just because a contract is signed doesn't mean it's valid. There's something called an unconscionable contract. That's a contract that is so extremely one sided, it's so unfair that is shocking to the court. And it's often, these contracts often come about because of unequal bargaining power between the parties. So usually those contracts are not enforceable and the courts will invalidate them. Let me give you a quick example. As always, I'm going to use myself. Early in the 2000s, anybody that knows me know I'm a car girl and I love cars. So I bought me a car. I bought a brand new Expedition. It had 3 miles on it. This was in the early 2000s. Straight out the showroom, it had 3 miles on it. It had the plastic on the seats, everything. So I'm driving this car. I've had expeditions before, so I know what the car is supposed to drive like. I know what it's supposed to do, right? The car is just acting a fool. It's doing all kinds of things. And I'm just trying to figure out what is wrong with this car. So this is the dealership I got the car from is the one that I had bought probably 5 or 6 other cars from. I had a relationship with them. Okay. So I negotiated for this car just like I did all the other ones. But this one was acting up. It's acting a fool, right? So what happened was I finally my lawyer brain kicked in and I'm like, something is wrong. Remember, I said there was only 3 miles on the car when I bought it, but I went and ran the VIN number on the car. Turns out a police report came back on the car. The car had fallen off the transport truck, and the dealership called themselves fixing it. Then after that, it got vandalized. Someone had busted the windows, pulled the radio out, and then the dealership called themselves fixing it, and they sold it as a brand new car. And it ended up being that happened to 8 cars, 8 expeditions, and I ended up being one of the people that got one of them. Well, of course, the lawsuit was on by then. It was on. I filed that quick. Now, I said that what my argument to the court was that to void the contract where I purchased the car on the grounds that it was unconscionable. Because when I was bargaining with the dealership to buy the vehicle, they knew it was damaged. I had no idea it was damaged. That's an unequal bargaining position. Had I known it was damaged, I would have negotiated differently. So what they should have did was disclose that that vehicle had fallen off the truck, it had been vandalized, and they done fixed it twice. They said none of that. So I argued that because of basically their lies and the information they were held. So don't think fraudulent concealment or anything like that yet. Think shocking. Remember, I said it's an extremely one-sided contract that's shocking. It shocks the court. So anybody would be shocked of what I just told you, right? So that worked out that way. I got some money. I went and bought a Navigator. That case, got concluded. But so you want if you're in a position where you find out or that you have an unequal bargaining power, one side knows something that the other side is entitled to know, that's the most common example, then that's actionable in court. You can get that contract voided for that. And I say that because just like the example I gave, everyday life, that happens. Like the landlord might know that there's a bad pest problem, that there's mold in the apartment. The landlord knows that. You don't know that. So you're at an unequal bargaining power. That's an unconscionable contract. If you were on the podcast last week, you heard me talk about a contract of adhesion. That's a pre-printed document that is a take it or leave it kind of situation. Those can be unconscionable too. I'm going to talk about those a little bit more in a minute. But what I want to tell you and finish up talking about an unconscionable contract where your bargaining power is different, those can be a violation of the 14th Amendment of the due process, 14th Amendment of the Constitution, which is the due process clause. I'm sorry, the 14th Amendment of the U.S. Constitution is the due process clause. And that's because, okay, so like in terms of not being deprived of rights, liberty, property, things like that, the way the contract is written is unconscionable. It can be enforced under the 14th Amendment of the Due Process Clause. So your unconscionable argument will fall up under there. I don't want to get too specific because that kind of gets in the weeds for you guys, but I just wanted to bring that part up and let you know that part. Let me pick my notes up over here because my printer is just doing whatever it wants to do. I don't know if y'all can hear it in the background, but I do want to go back to this contract of adhesion. If you were on last week when I talked about that's a pre-printed contract that's handed to you, and it's handed to you in a take it or leave it kind of fashion. It's usually drafted by one party, the person who pre-printed it, and it's in their favor. So when they hand it to you under the condition, they really make it like you don't have an opportunity to negotiate. Sometimes you don't have an opportunity to negotiate, but sometimes you do. And so that's why any contract you're given, I always say, of course, remember we said read it. But if you see something in it that you don't like, ask about it and say, hey, what's with this? I don't want to do this part. Can I change this part? And so that's an important thing to know. Like I said last week about a contract of adhesion. Um, a lot of times, of course, leases are pre-printed. When you buy your car, it's pre-printed. Even when you buy a house, a lot of times. But I read those things and I scratch out what I don't like now. Sometimes the place you're at, they're gonna say it's a deal breaker. Like you have to take our contract like this, um, or don't do business with us at all. And then sometimes they'll let you make the changes. You don't know until you ask. It's just that a lot of people don't know they can ask. So so, a lot of times, contracts of adhesion they can be overruled by the court. They can be reformed or changed because they were presented to you in a take it or leave it way, especially if you were at a disadvantage in the negotiations. So, a lot of what I'm telling you right now is so you can have awareness of these things. Like you may want to watch this video again, or at least you might know if some of these circumstances have happened in your life, like, hey, I might have a case here, I might have a lawsuit. Another thing that you'll recognize is a contract of adhesion. Everybody's done this. When you downloading software, when you getting on anything and it says accept these terms. And if you don't accept the terms, you can't use the product. Well, the product might be your whole computer. I mean, you bought the computer, you get it home. Of course, you're going to accept the terms because you need to use the computer. But that's when you hear about these big lawsuits against Microsoft, against Facebook, against all these places. And then they try to say, oh, it was in our terms and conditions. And then the court is like, okay, but did you let 6 million people negotiate the terms and conditions? No, you did not. So that's why I'm bringing this up. Like, just because you sign something doesn't always mean it's going to hold up in court. They're used because they're efficient. They make business go faster, but a lot of times they're not fair to the person who didn't draft it. So I want you to know that. What time is it? 6:23. Time always moves really fast. I want to talk to you about damages that you can get from a breach of contract. I am going to get to the part of the provisions of the contract that you need to be looking for when you're reading a contract, because after today, anybody on this podcast, they're always going to read their contracts. No, you're at least going to be able to skim through it once I tell you what you're looking for. I'm going to get to that part in the second half of the podcast. But right now, real quick before I go over damages, let me say hi to all these wonderful people that's saying hi to me in the comments. Hello, Gloria Mitchell. Thank you so much, because I was on here like, is the podcast working? There's nothing in comments and my screen looks different this time. That's what's kind of throwing me off. So thank you for acknowledging that the world is out there. Thank you to all friends of Gloria Mitchell that get on. Thank you so much for your support. I appreciate it. Of course, my wonderful son is on here. Hello, Christopher. That's mommy's baby. He's getting ready to be 30 in a few days. He won't mind me telling you that. He's going to be 30 on April 11th. Happy early birthday to my baby. I'm going to see him on that day. Jazzy Jazz, Jasmine Beals is on here. Thank you, Jazz. And look, okay. Hey from Nashville. It says it's just GG7. Hello, hi. And yes, so I wanted to take the time to say hi because I be meaning to do that every week. But y'all, I be into this information that I want y'all to get because it can really help when you out here. Because sometimes people signing stuff, they don't know nothing about nothing. And then they call me and, I can get it fixed. But, that takes some doing. And we want to catch it on the front end, right? Let me tell you about damages. Say you have a contract and it's a valid contract, so you can take it to court and you can sue on it. Watch this. Either you're going to sue or you're going to get sued. This is part of what you should be looking for when you skim through the contract. I'm going to tell you the rest of them later, but this is about damages. The damages for breaching the contract is going to be in the contract. You want to know what those are. There's all different kind of damages. You got consequential damages or special damages. You got liquidated damages, restitution, reliance damages. You have punitives, actual damages, that kind of thing. Let me tell you real quick. Actual damages is your actual damage. I'm going to use my case again. Real quick. I had an Infinity Q50 that the short story is a car repair place put a new engine in it. I drove the car from Texas to Mississippi. The engine blew up in Mississippi. Okay, I had a 6 month, 6,000 mile warranty. I was 41 days and 1,700 miles into the warranty. They are refusing to pay for the engine that they put in that blew up. Okay, so my Infinity was paid for. So I got the value of the car. The value of the car. Okay, then so what happened was I had to get another car. So I got that. I ended up not having to rent a car, but like if I had to rent a car, stay in a hotel while I was in Mississippi, those are actual damages. That's money I spent, money that I've incurred because of the breach. What's the breach? They are not honoring the warranty to fix the car. Remember, I had a 6 month, 6,000 mile warranty to fix the car. They say they not going to fix the car. So now I'm suing them for breaching that warranty agreement. Okay, so actual damages is the actual money I'm out of. Okay, then there's special damages. Um, that's stuff like profit or loss. Like special damages would be, okay, I couldn't go to work for a week. I missed this money because I was sitting in Mississippi and I didn't have a way to get home. Those kind of things are special damages. Um, Let me see what other. Okay, so I'm asking for punitive damages because punitive damages are damages that are awarded to punish a wrongdoer for what they've done. So in my case, what I'm asking for punitive damages against the company that won't fix my car because it's wrong to not honor a warranty. They should be punished for that. Punitive damages are meant to keep a wrongdoer from doing the same conduct again. So if they get charged with punitive damages and I'm going for a big number, I want like really I want about $250,000 in punitive damages. What y'all don't know is this is way back from 2022. We get ready to be 4 years out that they've been dragging this out where they won't fix my car. So all this time I've been going, my damages are running. That's why, I mean, I care, but I'm just like, hey, the longer you drag it out, the more worse it's gonna look for the jury in my jury case. So anyway, I'm going for punitives because they had a warranty they should have honored. So restitution, of course, deals with criminal matters. That's when you pay a victim back for damages, whether it's you were drinking and driving and you tore up property, whether it's or you were in an accident and driving on a suspended license, you hit somebody's car, you hit a person, they have medical bills, anything. Anytime you hear restitution, that's always dealing with criminal. That's not the word on the civil side. Um, Liquidated damages. This is what you need to look for in a contract because a lot of times in the contract it'll say if you breach this contract, let's say a lease, right? The lease might say if you breach this lease, we are going to um, take $2,000 as liquidated damages. It's basically one flat fee that they're going to take to account for their damages. A lot of times, liquidated damages might be better because the actual damages, remember the number I said before, the actual number could actually be higher than the liquidated number. But that's just the number that the party is like, I'll just take that and I won't, I'll be good with it. So liquidated damages are usually always in the contract. So the point of this damages discussion is when you're going through a contract, you want to know what the damage calculation is and how they're calculating it. Like an apartment might say, we want liquidated damages in the amount of $3,000 a month. You like, well, heck, the rent is only $1,500 a month. Why would I pay them twice the rent every month for liquidated damages? So you need to know what is the penalty for breaking the contract. You need to know that because sometimes you want to voluntarily break a contract. It's something to do, but you just want to know what do I have to pay to break this contract. Sometimes it might make economic sense to break a contract and just pay the damages, but you need to know what they are first. Hey, Lottie Covington, Lottie Dottie over there in Nashville. Hey, okay, I'm sorry. Asking my line sister, y'all. I had to say hi. Okay, um, so just remember, damages is important. We need to know what they are. Now, this is gonna seem like a whole different side note. I'm gonna tell y'all this side note, and I don't think, you know what, we're not gonna do the break on this session. We're not gonna do the break. I'm just gonna go straight through. Okay, I'm gonna tell y'all this part. It may seem like a side note. Then we're gonna get back on track. But I had this in my notes because this came up. For anybody out there that has filed bankruptcy, if you filed bankruptcy and you got a discharge on your debt, let me tell you how sneaky these creditors and people are. They will call you back and ask you, are you going to pay the debt? And some people actually agree to do it. Now look, the discharge wiped that debt out. It canceled the contract that you were under to pay the debt. When the bankruptcy judge gave you the discharge, it canceled that contract. If they call you and ask you to pay and you say yes, you pay any amount. If even if you owe 6,000 and you agree to pay 200, it brings that contract right back to life. And I don't know why people do this, but for some reason they do it. They agree to pay a debt that they got discharged from. Don't do that, because it's gonna, if you do that, it's gonna bring that contract back alive, and then you'll be responsible for that debt again, and you can't file a bankruptcy on it again. So I just want to throw that in as a side note, because I've seen that several times, and I want to. And since we're talking about contracts and the debt that you incurred, you had it because of a contract. I want to bring that up. A contract that was dead can be revived under certain circumstances, and that's one of them. Don't do it. Okay, now the much promised part. And then we're going to talk about too how to negotiate from a position of strength. But I want you to know all this contract stuff first before we talk about that. So when you're going through a contract, this is what you need to look for. You're going to start on page 1 and you starting at the top. The first thing to do is to look at the parties, who they say the parties are. It'll say, this is an agreement between, Mary Smith and Nichon Mitchell. Make sure the names are spelled right. Make sure that those are the correct parties. Because sometimes, like, one company may own another company or this and that. Make sure the parties listed are correct. Make sure you know who you're contracting with. Make sure the dates are right. This contract starts effective April 2nd, where you might have had an agreement that it starts effective April 10th. Like, you may have a grace or something there. Make sure the dates are right. Make sure the addresses are right. So you want to start at the top and make sure they got the basic stuff right, because a lot of times you end up fighting over that. Or sometimes a company will spell the name wrong and do all that kind of stuff. And the person be like, that ain't me. I don't know who that is. Like, if I get something and they say Nashon, that's how they spell Nichon. Like, they didn't ask me. They just spelled it Nashon. I'd be like, I don't know who that is. So, they got to spell it right. They got to get it right. So, in any event, check all that stuff. Okay. Another thing to check in the contract is a dispute resolution provision. Whenever there's a dispute resolution provision, like, we're going to mediate, we're going to arbitrate, you are giving up your right to a jury trial. Look, even in the civil context, we already know in the criminal context, you have the right to a jury. We know that from the Constitution and everything else. But even on the civil side, by statute, a lot of states have created the right to a jury trial. You give that right up in a dispute resolution provision. It's going to say, you give your right up to a jury trial. You got to go to arbitration. You have to go to mediation. You want to know, is it binding or not binding? Even if you go, do you still later have the right to go to court? Who's paying? A lot of companies, they will pay for the arbitration and mediation if you do it. It's just you give up your right to a jury trial. Now, they done got real slick lately, and what they doing is making people give up their right to be part of a class action lawsuit. Not everybody is doing it, but I'm seeing them do it, and it's catching steam. So you want to know, have you given up your right to a class action lawsuit? We all know it's a lot going on out here. It's stuff in the food, it's stuff in the water, it's credit scams and everything else. If you give up your right to a class action, be in a class action lawsuit, you want to know that you're doing that. So look for the dispute resolution provision and see. We have a question. It's a good one from Mama's favorite son, and it says, "Can I get out of a contract because I'm referred to as Christopher Shannon number one or two?" Um, okay, right. So the whole time I'm raising my son. So especially once my son Christopher Maurice Shannon the second, especially when he got to the age of 16 and he's working, he got a bank account and all this other kind of stuff, which he had since he was 8, but it really mattered once he got older. I made him start really using the distinction Christopher Shannon 1 and Christopher Shannon 2. Yes, if they can't identify the right Christopher Shannon, then who are we talking about? That's why I said in the beginning, make sure the parties are right. But, sometimes too, I mean, they need to make sure they got it right. But if he gets something in the mail that says Christopher Shannon, then he's like, that's not me. I'm Christopher Shannon the second. He's not Christopher Shannon Jr. He is Christopher Maurice Shannon the second. So yeah, he could probably, get out of it. If they don't have the right named party, then yes. Um, okay, so we were at dispute resolution. Another thing you want to look for is a paragraph that's going to be called choice of law or choice of forum. What that is you've seen it. If you've read the contract, you've seen it. It'll say if there's any dispute about this contract, it's going to be handled in the state of Texas. Like, right, I'm in Texas, right? Mine might say in the state of Texas, but because of internet business and things flowing back and forth, it may not say that. I may be in Texas down the street at a quick oil change place. And when I sign off on that, it'll say any dispute is out of the state of Montana because that's where their corporate office is or something, right? So what you want to know is whatever you may have to go to that form to sue, but even if you don't have to go to that form, there's instances where I could file here, but Minnesota law will be used. Texas law won't be used. So you want to know, do I have to what state is governing this contract? What state is this contract is the law that's covering this contract? Because it's not necessarily the state that you're in when you sign it. It's important to know that. Another thing is we talked about a breach of a contract. What you want to know is what actions constitute a breach. Then sometimes they might spell it out. It might be a paragraph that says, breach a contract or how this contract is breached. But most likely, it's not going to be pulled out of the contract like that for you. You're going to have to know it when you read it. For example, if you buy in a car, it says failure to pay the note is a breach of the contract. Maybe later on it might say, if you go to like a tote the note place or a place where people go when their credit is a little bit lower, it'll say failure to give us an updated address is a breach of contract. And when we find the car, we're gonna take it. You want to know what in an apartment building, they may say these days they'll say failure to keep renter's insurance is a breach of the contract. You want to know what conducts or actions constitute a breach, which means now you are in jeopardy of either being sued or paying damages. So you want to know those things before you sign it. Now, um, when I said earlier about the bankruptcy and not reaffirming a debt after you've been discharged, the other thing is a lot of times people will call about an old bill. It's 6 years old, 7 years old, 8 years old. If they're basing it on contract, the statute of limitations might have run such that you don't have to pay you don't have to pay the debt anymore. Like they can't sue you on it. The statute of limitations has run, so they don't have to sue you. Now, in Mississippi, on written and oral contracts, it's a 3-year statute of limitations. That's Mississippi Code 15-1-49. But sales contracts under the UCC is 6 years. Unwritten employment contracts is 1 year. So judgments, you got 7 years to enforce them. This is a little nugget real quick. Way back when I did the child support and divorce and stuff, I said way back a few weeks ago, I did it. I forgot to say, everybody out there with a child support order, when your kid gets 18, if there's a rearage in the child support, get a judgment for that final number. And in a lot of states, you can enforce that judgment for up to 10 years. But apparently in Mississippi, it's 7 years that you can enforce a judgment. But even when that 7 year period comes, you can go to court and renew for another 7 years. So the best thing you can do for your child that has hit age 18 in every state, 21 in Mississippi, if there's arrears on the child support, go get a judgment for that total arrears amount. And then you can wash your hands of it if you want to and let the kid enforce the judgment, or you can enforce the judgment. But so anyway, that's a little secret. Let me see. I have a question. Nichon, do you create contracts for small businesses for services? Yes, I do. I create contracts and I also review them. If you're a small business and you have vendors you're doing business with, I do have clients that shoot me the contracts and I review them. Usually, any contract, any size, I just charge $125 for that. I review it and then I write you back and say, hey, these are the provisions that either you should know about, that you should renegotiate, or I can help you renegotiate, for an additional charge, whatever. But yes, I do have that service. Thank you for asking. So real quick, in Tennessee, the statute of limitations for most contracts, for like a breach, is 6 years. And so you want to know how long the statute of limitations is in the state that you live in case there's a breach. But the other reason you want to know is because if somebody's calling you up about an old debt, the reason you owe the debt is because of the contract. Well, if they can't sue you on it, feel free to hang the phone up. I'm just saying. Okay. So you also want to know how to cure the breach. Remember, I said you want to know what actions constitute breach. But when I say how to cure the breach, that's the legal language. That means, how do I fix it? Lord, how do I fix it? Right? So that's called curing. So what happens is it'll say, if you fail to pay the note, like if you have a car contract, right? If you fail to pay the note within 3 days of it being due, you are in breach. However, if you pay it before 30 days hits, that cures the breach. So it'll tell you what the breach is, and a lot of times it'll tell you how to cure the breach. That's in there. You want to know that part. So kind of what happens is, now some of these people, depending on who it is, I remember back in the day, GMAC, anybody finance a car through GMAC, you ain't want to play with them, because if it says if you don't pay by the 3rd day, you in breach, they'll come pick your car up on the 3rd day. Do I have any witnesses here? Okay. They'll come pick your car up on the 3rd day. Some other ones, they will wait until the cure period runs, because really, when GMAC, but see, it was before I went to law school. I was younger than I was 19, right? So say it says you're in breach if you don't pay on the 3rd day, but you got 30 days to cure. If they pick it up on that 3rd day, I could really go to court and say, Your Honor, they didn't give me a chance to cure. They didn't give me a chance to fix it. And a judge be like, you got to give her a chance to fix it. So that's why you want to know what actions are that you can take to cure it, and what the cure period is, the fix it period. You want to know what that is. Okay. Listen to me. Something called assignment of rights. You want to know somebody just called me about this. Oh, yes. So I had a friend that just called me. I'm not sure if they're on right now. But he called me and said he co-signed for a debt. He co-signed for a loan for somebody. And the original person that he signed with, that the loan was with, that's not who's suing him right now. It's a whole nother company. And he was like, they can't do that. I didn't sign with them. I didn't sign the loan with them. And I'm like, hold on. If you agreed to let that lender assign your contract to somebody else, then yes, they can do it. So what that looks like is it'll say you agree that we can assign this loan to anyone we want to. We can sell it. We can write it off. We can give it away. Side note, real quick, y'all getting a good little law school lesson right here. There's a whole class in law school called secure transactions. And that's basically how business is conducted, through documents, through papers, like a check, right? A check is a secured it's a secured instrument. But also, any piece of paper securing a debt is covered by secure transactions. It's called chattel paper. Even as a regular person, Say I loan my cousin $8,000 and I have it written down. I got a contract on paper, right? Say the cousin don't pay me and I'm sick of fooling with the cousin. I can go sell that debt as a regular person. I don't have to be a business, a bank, a GMAC, anything like that. I can go sell it to a credit collection company. If they owe me $8,000, the collection agency might give me $4,000 or $5,000, and then they gonna go after the person for the eight. So that's why if you lending somebody money, you want to put in there your right to assign it to somebody else, because then you can just sell that. Now, the other thing, real quick, helpful to know, when you got chattel paper, a piece of paper that secures a monetary debt, that's collateral. You can hold that. So what a lot of times what banks and other people do is all of the loans they got that people owe them, they use that as collateral and they get loans against it. So in any event, that's just a little side note tidbit. People don't know that as a regular person, you can call up a debt collection agency and be like, "Hey, I got, you know, this person. They owe me $8,000, $10,000, whatever. They won't pay me. Okay, how much will you give me for it?" And they'll buy the paper from you, which is buying that debt, and then they're gonna go after the person and collect it. They're gonna, of course, try to get the whole sum. And so that's how that works. So you want to know, if you are entering into a contract, is that person putting in the contract that they are able to sell that to someone else? 9 times out of 10, yes, it's in there, because they want to get rid of it if it's bad debt. They don't want to have to keep collecting on it, so they want to assign it to somebody else. Now, the other thing about that assignment is it's going to say, hey, not only do you owe us, but you agree that your heirs and assigns. Remember all my people out there that I do estate and trust work and I do your will and stuff for you, your heirs and people like that. They say not only do you owe us, but your heirs will owe us too through your estate. Not saying you're not personally binding your heirs, but what you're saying is, I'm leaving permission behind that my heirs, my beneficiaries, whoever gets my estate, that they will honor this debt as part of my estate. They're not honoring it personally. They're whoever is over your estate as the executor in their official capacity, not their personal capacity. They are agreeing to pay this debt. So you're signing that too. You should know and understand that you're doing that. We already talked about damages, knowing what damages are in there, what calculations, how payments look. You want to be real clear about how to make payment. So people get their credit card statements. I bet nobody, credit card, bank statements, anything like that, I bet nobody is reading the back. There's helpful information on the back about how to pay, where to pay, how to pay extra to pay on the principal, so you can pay it off faster. Look, sometimes if you paying something off by mail, which people rarely do anymore, but sometimes it's better to do that way. If you pay something off by mail, it's a different address than the payment address. If you send it to the wrong place, it's not going to count. If you send it to the wrong place, they're going to misapply the funds. So that's why, once again, reading is fundamental. Know where you're supposed to be sending this stuff. I got to move fast because we got to get to how to negotiate from a position of strength. Okay. The other thing that you want to look for when you're reading a contract is, if I have a problem with this contract, who do I contact? Who do I give notice to? So inside the contract, it's going to say, hey, notice to. Oh, it's going to say, so say it's me and I'll just use a car place again, GMAC, right? GMAC is going to say, you got problems with this contract, you notify Jane Doe. She's the director of customer service. This the address, this the phone number. And then I would say, hey, if you got a problem with this contract, notify me. But I might say notify my lawyer. It might say notify my husband. Like, that's who is the person to receive official notices about the contract, because there's different places in the contract that says, if you're going to take this action, you have to give us official notice. Like in a lease, if you want to sublet your apartment, you may have to give official notice to the property management company, not the actual landlord himself. Different things like that. You need to know who official notices go to. And do they go by registered mail, certified mail? Do they go by FedEx, carrier pigeon, whatever, right? I need to know how to send it, because you have to do it in a way that complies with the contract. Apparently, I have some questions. Let me see what they are. What is the statute of limitations for an employment payout up front? That's a question you got to call me about, because that depends on a statute of limitation. Questions are always dependent on the state that you're in. And it always, you say employment payout up front. Do you have an employment contract? Are you an at will employee? That kind of thing. So it's a lot of other questions that have to be asked in order to get to that answer. So then it says for Texas, for Memphis. Um, so okay, so here are the states, and so I kind of went through employment for Tennessee, but I still need to know if there's an employment contract or no employment contract, a few different questions like that. So just call me, and the person that asked the question has my number, so that's fine. Let me see if I'm missing any questions. Don't think I am. Okay, so how to negotiate from a position of strength. Well, you know what? Wait a minute. We're gonna go over just a little bit, but check this out, because I gotta tell y'all the defenses to contracts. Now, you got kind of two different ways to defend against a contract. One is you can, if you're being sued, you can mount a defense based on how the contract was formed, or you can mount a defense based on how the contract was breached. So if you're going to mount a defense based on how the contract was formed, I'm going to go through these kind of quick, and I'm sorry, but watch the replay. Um, you can say, look, this contract was ambiguous. You said one thing here and you said another thing over here. And so, they cancel each other out. So the thing that you're talking about, sir, is not valid. You can say you signed it under duress or coercion. Remember when I said they just hand you a contract of adhesion and you don't get a chance to negotiate it? A lot of times, if I'm just handed a pre-printed contract and I start scratching out and I want to do stuff and they say, ma'am, no, we don't accept that. You either have to sign that contract or we're not going to give you the service. I sign my name and then I put sign under duress and I give it to them. I've been doing that forever. And so, just that's just a little clue. And so, all right. Fraudulent inducement. That's another popular one. You were fraudulently induced. Kind of like the situation I said with my car, with my Infinity, when they said, oh man, you got a nationwide warranty. Whatever happens, wherever it happens, we're going to cover it. And then turns out they didn't cover it. So yeah, fraudulent inducement. You said things just to get me to sign this contract, just to get me to do business with you. And I relied on those things that you said, but you never intended to do them. So that's fraudulent inducement. Mutual mistake is, and this happens, sometimes people contract to do something, and this person thinks they're doing one thing, this person thinks they're doing something else. And so each person thinks that they have the same understanding, but really they talk about two different things. You can cancel the contract for that. I know it sounds crazy, but it does happen. If I can think of an example while I'm talking, I'll tell y'all one. And then of course we talked about unconscionability. So that's what you do, the contract formation. Now, if you want to talk about breach of a contract, now these are the ones you want to use if somebody is suing you about a bill. There's something called accord and satisfaction. That means, we had an agreement and I paid you an amount of money. Now you can't come back and ask for the rest of the money, ask for more money. Like, we had an agreement, whatever the agreement was that satisfied the contract, I've already satisfied the contract. You cannot come now and ask for more. Economic duress, failure to mitigate. A lot of time, if you are, so kind of like the situation with my car, when it blew up and it went down, I got damages, right? I don't have my car. So I didn't get a new car right away because I was trying to get them to fix my car. Let me tell y'all what happened. I didn't even tell y'all the bad part. The mechanic who had my car and the company wouldn't agree to fix it, he sold my Infinity Q50 at auction. He sold it for the bill and the storage fees. So on the day he sold my car, then my car is gone. Now I need a car. So I didn't buy a car before that because I'm trying to get these people to fix my car. The people wouldn't fix my car. So at the point that my car is gone. I have a duty. I can't. So now, remember, I said it's been 3 or 4 years. I can't sit this whole time without a car. I have a duty to mitigate my damages, which means kind of reduce them down. You have a duty to reduce your damages down to the lowest amount possible. You can't just, willy nilly, like, okay, if I was stuck at a hotel, I don't go stay at the Ritz. I can stay at a Hampton Inn. I ain't got to stay at the Motel 6 either now. But but I don't stay at the Ritz either. You have a duty to mitigate your damages, which means to bring them down and keep them as low as possible. Okay, so let's talk about negotiating from a position of strength, because then if I do that for 10 minutes, then we're just 5 minutes over. Let me see if I have, this looks like a question. One moment. As a programmer, when should I seek a wet versus digital signature versus an acknowledgement? Is there a legal difference between those types? Um, yes. I don't know if there's significance to the part of this question that says as a programmer, but the question, when should I seek a wet versus a digital signature versus an acknowledgement? Okay. So a lot of states have passed laws, and then there's federal laws about digital signatures, and so you should get a wet signature when that's what's absolutely required by the person involved in the transaction. Like, say you're buying a house, some maybe they're like maybe Rocket Mortgage, because they do a lot of online house buying. They may accept a digital signature, but if you closing at your local bank, they want you to come in and sign wet. So the big basic general answer is seek a wet signature when the person involved in the transaction requires a wet signature. Otherwise, most of the laws, state and especially federal, are moving towards treating a digital signature the same as a wet signature. So, so that's how you determine if you need that. An acknowledgement, um, is so usually, I mean, in terms of a notary, in terms of like notary stuff, or in terms of signing something, an acknowledgement, usually the person has already signed and they're just acknowledging that, yes, that's my signature. A lot of times people, you'll hear them say, don't sign something until you get in front of the notary. Now, hear me good. That's generally the best course of action, because people don't understand the difference between a jurat signing and an acknowledgement signing. But technically, if it, so there's that passage when there's the wording when you're getting ready to get something notarized. Technically, if it says for the notary, I acknowledge that this person came so and so and so and so, that person can have already signed the document. They just come in front of me and they acknowledge that that's their signature. A jurat is the one where it says, I swear affirm, the person that comes in front of me. That's when the person can't sign first. They have to come in front of me and sign. And then technically they're supposed to raise their right hand. They're supposed to swear to whatever the document is. Like when you get a divorce and it's a petition for a divorce. I swear that I'm Nichon Mitchell and I've signed this document that is a petition for divorce and blah, 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 right? You do that, and then a notary accepts it and they fill the part in. So an acknowledgement generally is the person's already signed. They just acknowledge to you that's their signature. And you, once again, that is based on the requirement of the transaction that you're doing. So the technicalities like that, what kind of signature, when to sign, where to sign, does it have to be a notary? Whoever is conducting that transaction, they determine those things. Okay, so wonderful. Thank you for the question. All righty. How do you negotiate from a position of strength? The biggest thing is, a lot of it, y'all, to be honest, is you got to have a whole bunch of confidence in yourself, even if you don't have no confidence in yourself. Whatever you are trying to get, be serious about trying to get it. Like, even sometimes if it's unreasonable, right? A lot of times you can just punk people into what you want because your tone, your knowledge. Okay, now look, I will tell you, try to know as much as you can about the person you're negotiating with and about the thing that you're negotiating for. If it's a car, if it's a house, if it's a product, I negotiate everything. People that know me know I negotiate about everything. Look, my son's like, laugh out loud. Correct. I negotiate about everything, because I have such success with it. I do it for everything. It's a strategy called the best alternative to a negotiated agreement. So one example that they give is, say you're negotiating to buy a house, right? You in this house and you really like it, but you need her to come down on the price. So you like, I really like this house, but there's another house down the street that I like too. Now I want your house, but I need you to come down $10,000. So sometimes people won't move if they don't think you have another option. So really this whole best alternative to a negotiated agreement is basically, that's basically your plan B. Because you can use your plan B as your leverage for plan A. But all of that works in conjunction with doing your research on the party that you're negotiating with. Like I had a negotiation with Walmart, and I'm telling you right now, Walmart don't want to settle for nothing. They had to settle the case that I had because they were flat out wrong. They fired someone who was on FMLA leave, and you absolutely just can't do that. So Walmart, though, even though they're wrong, they don't care. They they really they like to stand their ground. But let me tell you what makes people see the light: when they know they get ready to face a jury, when they know they get ready to have to go to court, or when they know they get ready to have to pay, so they might as well pay you some on the front end so they don't have to pay more on the back end. But the only way to get them to that realization is to know as much as you can about them and as much as you can about the thing you're negotiating, and then hit people at their weak spot. So a lot of it is psychological because um you got to be able to get into the person's head and understand why they are negotiating the way they're negotiating. What is it that they want, or what are they trying to get? Because if you know that, you can also leverage that. So I'm trying to think if I can think of an instance. CJ, if you can think of one, drop it in the chat. If I can think of an instance where I use that. Um, but a lot of it is, well, you can use that at work when you're negotiating for a salary. You know what the bosses want. You know what they need. You know that the last three people they hired for that position didn't know what they was doing, and your boss is under pressure to get somebody in that spot, or they about to lose their job. Like, right? You know what people's motivation is. So you leverage that. What is their motivation? What is it that they're looking for? What emotional drivers do they have that's making them make the decisions and choices that they are? And then you exploit that. You find a way to use that basically against them. Sounds bad, but um so yes, I'm sorry, I'm going through my notes on this. Okay, yes, that is another one. Avoiding immediate concessions. Like if your initial offer or something is rejected, don't negotiate against yourself. Don't drop. Like right now, I'm trying to sell one of my cars, and I have it listed for $8,000, and I keep getting messages from people that say, "What's the least amount you'll take?" And I'm like, I'm not here to negotiate against myself. I listed it for 8,000 because I want 8,000. If you have an offer, come with the offer, but don't ask me what's the least amount I would take. 8,000. That's the least amount I will take. So, but if they took the time to do the research or to find out more, like some people are on there to ask me, oh, okay, can you tell me about the car? Why are you selling this and that, blah, blah, blah. Then, maybe they could come better with they offer. But asking me what the lowest is like, because so then I say, 7,000 or something. Like I'm already giving concessions. That's going to hurt your position because once you do that, it's like they're smelling blood in the water and they're going to come for you. So learn to stand firm on that. I want to know if anybody has questions about negotiating from a position of strength, because we are about to be almost at the 5-minute over mark, and I want to make sure y'all dropping the questions in. So go ahead and if you subscribe to the channel, you can get the past podcasts. I think it takes 24 hours to load, but I've done podcasts on child support, divorce and custody. That was one. I did one on life insurance. Well, insurance generally. I covered life, health, home, and auto. I did a podcast that was Ask the Attorney. People just ask questions. So anyway, there's previous podcasts you might be interested in, and you can see those if you subscribe to the YouTube channel. And then, of course, if you just go ahead and like it for me, that helps my algorithm. Okay, I think I've covered all of the main ways that you can negotiate from a position of strength and not be. Now, look, all of that goes to though too. Like I can negotiate from a position of strength all I want to, but if the dealer is secretly hiding that the truck in the car was damaged before I ever got it. Now that's when all of the other things come in that I've talked about, the unconscionability, the duress, the this, to that. That's when your other defenses come in. But all things being said, when I got that car, I got a great deal. I didn't get a good as deal as I should have gotten though, based on the condition of the car, but I had no way of knowing that. I had to have a police officer friend of mine run the VIN number. I got the police report, and then I had to sue them to serve discovery to get the records from that dealership to figure out what happened. That's how bad they were keeping it under wraps. What do you recommend to make that deal? For car deals, with the dealership industry being more conglomerate or one company owning the city, what do you recommend to make the deal have the money to go to the same place? Wait, what do you recommend to make the deal have the money go to the same place? I don't understand the question. Redo the question really quick. And then, okay, what else about contracts? I think that may get my notes. Not have the money go to the same place. What do you recommend to make the deal? Type the whole question again. I still don't understand it. I don't understand what you're asking. I wish I could have some voice on here. That would help with the question. Okay. It is 6 minutes past. I appreciate everybody. Usually I tell you what the topic for next week is. I am working on something I want to bring to you guys, but I will post it and let you guys know what the topic is for next week. I really appreciate everybody. Write this down. It didn't scroll during this session. 615-596-3132. You guys send me a text or call me if you need something, 615-596-3132. And then if you text me too, I can shoot you my email and then you can send me the question. We can correspond back and forth, that kind of thing. I really thank everybody. I hope y'all have a great Thursday night. I'll see y'all next week.